Retrenchment is something akin to downsizing. When a company or government goes through retrenchment, it reduces outgoing money or expenditures or redirects focus in an attempt to become more financially solvent. Many companies that are being pressured by stockholders or have had flagging profit reports may resort to retrenchment to shore up their operations and make them more profitable. Although retrenchment is most often used in countries throughout the world to refer to layoffs, it can also label the more generic tactic of cutting back and downsizing. The above is a very informal definition of retrenchment. Retrenchment has more to it than just termination of employment by an employer. There are a host of legal provisions which govern the practice of retrenchment. Hi, this is Nikhil Sharma. Today I am going to tell you about the topic retrenchment. According to the Section 2, subsection 00 of the Industrial Dispute Act 1947 defines retrenchment as the termination by the employer of the service of a workman for any reason whatsoever, otherwise than as a punishment inflicted by a way of disciplinary action, but does not include A. voluntary retirement of the workman, or B. retirement of the workman on reaching the age of superannuity if the contract of employment between the employer and the workman concerned contains a stipulation in that behalf, or C. termination of the service of the workman as a result of the non-removal of the contract of employment between the employer and the workman concerned on its expiry, or of such contract being terminated under a stipulation in that behalf contained therein, or C. termination of the service of a workman on the ground of continued ill health. In a very famous case of State Bank of India versus Sundaramani, the Bombay High Court held that wherein the court held that an analysis of the definition reveals four essential ingredients, namely, there must be a termination of the service of a workman, first. Second, the termination must be by the employer. Third, for any reason whatsoever. And fourth, otherwise than as by a way of punishment inflicted by way of disciplinary action. Procedure for calculation of retrenchment compensation. While effecting retrenchment of the workman, it is obligatory on the part of the employer to pay the retrenchment compensation at the rate of 15 days' wages for every completed year, to be calculated at the last drawn salary of an employee. In case an employee has worked for more than 1 year, the procedure is that in case the subsequent period of 1 year is less than 6 months, then it will be counted as 1 year for calculation of compensation. While making calculations, the period of notice is also be taken into consideration. Section 25F provides the conditions precedent to retrenchment. According to this section, the employer must satisfy the following conditions before retrenching an employee employed for a continuous period of not less than 1 year. A. The workman has been given 1 month notice in writing indicating the reasons for retrenchment and the period of notice has expired, or the workman has been paid in lieu of such notice wages for the period of the notice. B. The workman has been paid at the time of retrenchment compensation which shall be equivalent to 15 days average pay for every completed year of continuous service, or any part thereof in excess of 6 months. And C. Notice in the prescribed manner in served on the appropriate government or such authority as may be specified by the appropriate government by notification in the official gazette. Globalization induces labor market flexibility which India is yet to attain due to its unwielding labor law system. It has started making attempts to achieve full employment of all resources and optimal social welfare, but several issues are left unanswered, including retrenchment. Retrenchment may be due to inevitable reasons, including rationalization or installation of new labor-saving machinery. An employer has a right to organize his business in any lawful manner he considers best, and courts cannot question its propriety. If reorganization results in surplus employees, no employer is expected to carry their burden. There is consensus of judicial opinion in deciding retrenchment on the facts and circumstances of each case. So this was all about retrenchment. I hope you liked this video. If you liked the video, do like, share and subscribe the channel.